Huge breaking news is JD demands a court decision now, asking for a summary judgment. That would mean no trial, no jury. That would be the judge making a decision right then and now. And considering that this is popping off right now, you know that certain Aquaman starlet is looking at this and wondering what new thing has been found. I mean, after all, they didn't ask for this with body cam footage, with charitable donations, with witnesses turning and on. Yeah, you and I, we're going to talk about this stuff today. Fun times, huh? Fun times indeed. Oh man, so hey there to all you fine folks on this fine day, by the way. I hope you are doing excellently. And this, it is big news, like big news. Some of the biggest stuff we've seen as of yet. Why? Because JD, he feels confident enough to say, let's circumvent the courtroom. Let's go around everyone, including the jury. I trust that you, judge, after seeing what we're presenting, you will make the right decision. Now, before we go over this bombshell filing, and that's what this is, by the way, it is a bombshell filing. You might want to know what a summary judgment is. Now, giving credit where credit is due, Laura B. on Twitter is the one that actually provided all of this information. Props to her. Follow her there. Also, check out her podcast. Best way to catch up on this case. I can't say enough good things about it. But this is the rules of the Supreme Court of Virginia. Remember, we need rules from Virginia to understand this because this case, it's happening in Virginia. This is from the Practice and Procedures in Civil Action, Rule 320, Summary Judgment. Now listen to this definition here. Any party may make a motion for summary judgment at any time after the parties are at issue, except in an action for divorce or for an annulment of marriage. Now that part has to freak that certain Aquaman starlet out. Why? Because they have to be asking themselves, why now? Why didn't they file it after all of the charitable donation bombshells came up? Why not after all of the body cam footage bombshells? What have they found here that has made them this confident to say, yeah, we need a decision right now? Continuing, if it appears from the pleadings, the orders, if any, made at a pretrial conference, the admissions, if any, in the proceedings, or upon sustaining a motion to strike the evidence that the moving party is entitled to judgment, the court shall enter judgment in that party's favor. Now, if you want that explanation without all the legalese, QWERTY posted this with a lawyer. Check her out on Twitter, too. We'll go back to the more of this conversation in just a second. But it says, it's basically the judge deciding the case without a jury. You submit a motion for summary judgment with your arguments, and the judge decides if those arguments are enough, like there's nothing left to dispute. Now, with that description fresh in your mind, I want to tune into this courtroom bombshell. We're going to be looking at 2 pages attached to this, and then we'll return to that conversation with the lawyer because there's one other bombshell item that we have to discuss. Make sure you tune in for everything. Now, you'll notice, first of all, where this is coming from. It's coming, of course, from the Circuit Court of Fairfax County, but you notice what kind of filing this is. Calendar control order. Now, what that means is the hearing about this, it is already on the calendar, and you'll see that when we come to part 2 right here. Part 1, though, to be completed by the parties. You have your case number filed in. This is JD versus that certain Aquaman starlet. This was funny, by the way. So, these parts, they were redacted, but when you look at the email address and telephone number, I had to pull that out myself because they were still in the public document. Oops. Action requested by plaintiff. That means JD. He actually filed this. And the other box as well. You'll notice that they're blank. Now, part 2, to be completed by the calendar control judge. So, it's actually coming from the court. The action request it's granted. So, they're going to allow a hearing on it. They're going to allow all the steps going forward. This is for a summary judgment motion. And you have it set for, the hearing, it's going to be on 3/25/22. Remember, the court case itself, the main one, it kicks off 4/11, but there's another part to that we'll discuss in just a moment. You have your hearing time. You have the judge that's assigned to this. That's the judge that has always been on this case. You're going to have 1 hour dedicated to that. And tuning into page 2, you have a breakdown of how all of this it's going to transpire, culminating in a hearing. And again, you get your activities, you get your dates, you get your remarks, and you either get time or pages, depending on what they're talking about. So this process, it's going to open up with an opening brief. JD's team, they're going to present their argument. I can't wait to see what's there either, because I have the feeling there has to be something new here. Either that, or they feel that every decision, everything that's been removed, that makes this case so powerful that, well, you can make a decision right here and now. But that's going to come up 12/25/22. They give the time frame, it's got to be filed by a certain time. And this, it can be 8 pages. So you're going to present everything that you have with 8 pages. Now, you have a response to that. That's going to become from that certain Aquaman starlet. They get to do that with 7 days after the opening brief. So they have a week to reply. They have a week to put everything together. That's going to come up 3/11/2022. They can actually respond with almost double the pages. They get 15 pages to lay out their defense with this. And then you may have a reply brief. That depends. If the judge actually permits that. The judge, well, I think they would probably permit this, but this is going to again come up yet another week. Notice everything, it's staggering with weeks. With 3/18/2022, that reply brief, again from JD's team, that could be 7 pages in length, with the hearing, again, coming up, and 3/25/22, and you have 1 hour dedicated to that process. Within, would you make the case? Now, returning to that discussion with the lawyer, there is one point of contention that needs to be mentioned, and that's the fact that it may actually involve the counterclaim, not the main case, but we're unsure as to present. The lawyer actually says, well, they think that would be the counterclaim. He's just trying to get the counterclaim dismissed. QWERTY says, okay, I just want to be super clear that he wouldn't do this for the main case because I'm about to go chill on the Twitter squad with what you said. No way. He wouldn't move to dismiss his own case. It has to be the counterclaim. It's weird because he's technically still the plaintiff because the counter is based on the original claim. Yeah, when you look at this, no matter what, you either have the main case or you have the case that certain Aquaman starlet is going to try to launch in the aftermath. $50 million worth of case. They feel confident enough that they're saying, yeah, we want a judgment. We want a judgment right now. But anyway, let me know what you think about this stuff. And as always, appreciate the heck out of you. You make this channel work. Thank you. I cannot say that enough. If you want to help out the channel more, there are links in the description. We could always use your help too, so check those out. But you being here, that matters most of all. So thank you. Appreciate you. Ending here. See you soon.